So the long established principles of proportionality are going to cause some serious problems for the defense here. But it gets worse, Mark. We have something called consciousness of guilt evidence that the prosecutor gets to play around with as well. Consciousness of guilt evidence is when somebody's behavior following an event reflects the fact that they might be guilty, that they had a guilty mindset at the time. And so, what happens after the event? Mr. Anthony leaves there. He discards the knife in the bleachers, discards his bag from which he pulled out the knife in the bleachers, and takes off. Now, why is this relevant? Well, we defend people all the time in self-defense cases, and I can tell you that people who believe that they acted in valid self-defense are they're pretty proud of that fact. They're like, I had to do that. It wasn't pleasant. I didn't enjoy doing it, but I'm damn proud that I did. I'm really happy that I did. And, I did it because I needed to protect myself or a third party or for any other legal reason. They don't usually try to hide the weapon.
Flee the scene.
And then flee the scene. And guess what?
Yeah, man, I told you guys that was going to be a problem. I told you that was going to be a problem. You defended yourself. Then you ran away and ditched the knife. Conscious, what they call it, conscious behavior, whatever. That's on the books, man. Like, yo, you got to stay on the scene, place the knife, place the weapon down, and hand yourself over to the cops and tell them what happened. If it's self-defense, you don't run away and ditch the weapon. He is cooked, man. He's cooked. Oh, yeah, we're going to get to the Aryan Brotherhood in a minute, man. Make sure y'all support the channel. Support the channel, man. How many likes we got, man? Make sure y'all support the channel, man. Listen. We're going to get to the Aryan Brotherhood in a minute.
What the prosecutor gets to talk about all of that. Okay, if you thought you acted properly in self-defense, why'd you discard everything? Why'd you go running away?
Yeah, and prosecutor's probably going to get a jury instruction to the jury that's going to say something along the lines of, if you find that the defendant attempted to flee the scene and hide the knife, you can consider that as consciousness of guilt. And I think that's pretty clear. I think that is exactly what the jury is going to conclude from that kind of activity.
Yeah, Mr. Anthony may say, well, I left the scene because I thought these guys were still dangerous and were still threatening me and everything like that. But then, of course, that begs the question, why discard the knife right there next to them in the bleachers? Where he discarded the knife was just right there in the bleachers. He just armed them, if that's his theory, that these guys are dangerous. So I think this is going to cause problems.
It all bodes really bad for Mr. Anthony.
All right, so all that said, Mark, and I think both of us are saying, with the evidence that's presented right now, looks like a very tough case for the defense. So let's have some fun. Let's pretend that this guy was an AOR client. First and foremost, if this guy was an AOR client, no question, we would defend him in this case.
Yeah, that's an easy one. I mean, we'd actually be really excited about defending him in this case. Yeah. Assuming I would have wanted him, first thing I would talk to him is, why did you just shut up? Why didn't you call us right away? We would have told you to just shut up. We would have put the officer on the line. We would have talked to him. We would have, look, if there were important things to put out there in terms of self-defense, we would have said, look, our client felt threatened. He felt like he was at risk of serious physical injury here. We're going to give you all the facts later on. We just want to let you know that's the situation right now. We would deal with that situation. But how would we defend this case? We certainly wouldn't roll over and say, well, look at all the things Mark and Andy just said. This looks really bad. We better look to quickly cut a deal or something like that. No, we'd be gearing up in a big way. Well, first thing would be to talk to the client. Say, what the heck was going on? Explain to us why you did this. And, look, I don't know what he would say, but I expect that he would probably say something. I hope he would say something along the lines of, I was really afraid that I was going to be injured here. I can think of many things he would say, right? We know the twin brother was right there. Maybe it was 2 against 1. Maybe it was more than 2 against 1. Maybe he's in the tent of the other team. And when Mr. Metcalf stands up and gets into this, thing with him, the whole team gets up and now pumps up their chest and say, yeah, you got to get out of our tent. Now it's a whole group of people and he's worried. So now we've changed the analysis, right? We have several people against one person. He's also standing on the bleachers. Now, he's not super high up probably, but bleachers can be dangerous places. It's easy to fall over on the bleachers. It's easy to fall down and hit your head or roll down. So there could be a way to defend this case where Mr. Anthony is at a reasonable concern of an imminent serious physical injury.
Yeah, let's talk about that because people are confused about this point. The law allows you to use deadly physical force in self-defense or defense of others if you are reasonably concerned about imminent death or serious physical injury. That's right. You can use deadly physical force if a reasonable person in your position would have believed that there was an imminent risk of serious physical injury. There's an old adage, right? There's an old adage that's floating around right now surrounding this case. You don't bring a gun to a fist fight. We'll modify it a little bit for this case for Mr. Anthony. You don't bring a knife to a fist fight. And all he did was bring a knife to a fist fight. Well, that's an old adage. And
usually, right?
It's helpful because it conveys an important principle, what we're talking about, of proportionality. But as it turns out, there are many instances where you can validly bring a knife to a fist fight. You just explored a couple of them there. And remember, when we're talking proportionality here, we mean the type of you're allowed to use whatever force is what you're facing imminently. And so if there's a gang of people surrounding you, that could easily end up in serious physical injury or even death. If you're pushed over the bleachers, if you're worried they're going for a weapon, even if you're mistaken, because we have a statute in every jurisdiction that says a reasonable mistake of fact can be substituted in for a mental state in a defense statute. So in non-lawyer terms, that basically means even if you were wrong about the fact that you were facing deadly physical force, say, for example, he believed reasonably that the guy was going for a knife, but it turned out he was going for a cell phone or something like that. If a reasonable person would have believed that he was going for a knife, you can use deadly physical force.
Yeah, imagine you do some interviews in this case, and there are other people from Mr. Metcalf's team in the tent, and you say to them, do you remember this incident? Do you remember the day? Yes, yes, yes. When this thing started, it attracted your attention, didn't it? Yes, it did. And you were sitting down when that happened. Yes, you did. And then as the thing got more escalated, you got concerned and you stood up to see what was happening. Yeah, I did. Okay, that would be huge,
absolutely.
Right? That would be huge. Maybe were you standing up to try to gang up and fight Mr.